I'm a professor of the political science department here at Lincoln Center. I'm also an affiliate in urban studies and American studies. And it is my great honor to welcome you all here today for the Civil Rights in the 21st Century Symposium, sponsored by Fordham Law School and the African and African American Studies Department. Today we have Kristen Clarke, Esquire. Is Esquire spoken? Can we say that? Who is our keynote speaker. She's the Bureau Chief, Civil Rights Division, the New York State Attorney General's Office, Eric Schneiderman. Prior to joining the AG's office, Kristen Clarke worked at the NAACP Legal Defense and Educational Fund, and also the Civil Rights Division of the U.S. Department of Justice through the AG's Honors Program. She's testified before both chambers of Congress, the U.S. Election Assistance Commission, and numerous state and local legislatures on a range of civil rights matters. She also writes and comments frequently on issues concerning race, law, and democracy. And, in addition to all of that, has publications which include Barack Obama and African American Empowerment, The Rise of Black America's New Leadership with the late Dr. Manning Marable, and Seeking Higher Ground, the Hurricane Katrina Crisis, Race and Public Policy Reader, also with the late Dr. Manning Marable. Ms. Clarke received her AB from Harvard and her JD from Columbia Law School. And then, following the program, Farai Chideya will respond to some of Kristen's addresses. And Farai Chideya is a multimedia journalist, political analyst, and writer who's appeared almost everywhere: CNN, MSNBC, CNBC, ABC, Fox, BET, and HBO. She's currently a distinguished writer in residence at NYU. On the Arthur L. Carter Journalism Institute. She's a former on-air reporter and host for ABC News, CNN, and NPR, National Public Radio. Farai is developing new projects for public radio and writing 2 books on future works, and her talks often involve civic engagement, electoral politics, digital media, hip-hop, race, and politics. And she's traveled all over the world, and recently, about 3 weeks ago, had a piece in the New York Times, an extensive travel piece. If you all haven't read it, you definitely should. She's formerly held the position of professional residence at the Graduate School of Journalism at the University of California at Berkeley, was a visiting professor at the Annenberg School of Communication at the University of Southern California. She too holds a bachelor's in English from Harvard College. So it is my great honor and pleasure to welcome Kristen to the microphone for a keynote address, followed by Farai's response. I'll moderate a discussion between the two, and then I definitely want to leave time for questions and answers. Okay? So thank you all for coming. Have a great day.
Good morning.
Good morning.
I want to first start off by thanking Professor Greer for that very kind and warm introduction, and also thank Professor Watkins Owens and Professor Sylvain for the very kind invitation to participate in this Black History Month program event. To me, Fordham has been a real engine of Black intellectual thought and scholarship. I see the Institute here as really being at the forefront of such great, meaningful, and important work. And I have to admit that participating in the program today, for me, feels a little bit like coming home. I went to law school up the road at Columbia, and while I enjoyed law school a great deal, I spent virtually every waking moment when not in a law school classroom at the Institute for Research in African American Studies there, doing lots of work with the late Manning Marable. And I deeply believe that strong scholarship on the ongoing struggles that we face today with respect to race is what informs the backdrop against which civil rights lawyers do their work. So it's really great to be here and to see a packed room, to see a multiracial gathering of students who are deeply interested in the ongoing civil rights struggle that we face today. And I'm looking forward to the program today. And I want to thank Farai for her great work. And we're really looking forward to the exchange that we'll have towards the latter part of the program. Black History Month, of course, February is marked as Black History Month, but as we all well know, every month is Black History Month. So I view this as just a moment in a year-long celebration. I want to start off by first extending greetings on behalf of New York State Attorney General Eric Schneiderman. He has made civil rights enforcement a real hallmark and centerpiece of his time in office, and I'm looking forward to sharing with you some of the work that we're doing on the civil rights front here in New York. But we're here first and foremost to talk a little bit about the Civil Rights Act of 1964. And as some of you might know, the summer of 1964 will forever stand as a monumental moment in our nation's civil rights movement. Passage of the Civil Rights Act of 1964, which is one of the most comprehensive pieces of federal civil rights legislation to emerge from our Congress, was met with tremendous resistance. When the bill first came to the Senate floor in March of 1964, a solid block of Southern senators launched a filibuster to prevent its passage. Republican Senator Richard Russell of Georgia noted, "We will resist to the bitter end any measure or any movement which would have a tendency to bring about a social equality, an intermingling, and amalgamation of the races." Strom Thurmond also rose in opposition to the bill and proclaimed that these so-called civil rights proposals are unconstitutional, unnecessary, unwise, and extend beyond the realm of reason. And after 14 hours of a filibustering address led by Senator Robert Byrd of West Virginia, the bill's manager finally announced that he had successfully secured enough votes to end the filibuster and cut debate on the bill and bring the bill to a vote. A compromise version of the bill was passed in June of 1964 that was subsequently passed by President Lyndon B. Johnson. And this remarkable piece of federal civil rights legislation includes protections that we still rely on a great deal today. In fact, a lot of the work that I do in my office draws on many of the core protections that are embedded within the Civil Rights Act of 1964, which prohibits discrimination in areas ranging from employment, education, access to public accommodations, and housing. Outside of the halls of Congress and on the streets, the organizers of the March on Washington for Jobs and Freedom faced a world of stark racial inequality, injustice, violence, and opposition at every turn. And while their struggles helped to usher us into a new era and helped to beat back the institutionalized racism of Jim Crow, we know that there is still a lot of tremendous work that has to be done to advance the cause of civil rights here in our city, in our state, and our country. And that's what I'd like to focus the heart of my remarks on today, the contemporary civil rights struggle that we now face and grapple with today. The Civil Rights Bureau of the New York State Attorney General's office, where I work, is deeply committed to this work. We're committed to using every tool in our arsenal to combat ongoing discrimination across the state, and committed to leveling the playing field to ensure equal access, equal justice, and equal opportunity for all. And the Civil Rights Act of 1964, with its various provisions prohibiting discrimination, has proven to be a key tool in our arsenal. So what are we up against? For one, we're faced today with an enormous wealth gap between African Americans and whites. A gap that tripled between 1984 and 2009. Latest census data reveals these vast economic disparities, and in fact, right here in New York City, the rich got richer and the poor got poorer. In 2012, the poverty rate reached its highest point in more than a decade, and the income gap right here in Manhattan, already wider than almost anywhere else in the country, rivaled disparities that we see in sub-Saharan Africa. Those in the bottom fifth made $9,681, the bottom fifth, while those in the highest fifth took home $391,000, meaning the wealthiest fifth of Manhattanites made more than 40 times those in the bottom fifth. And that gap mirrors the gaps that we see in countries like Namibia and Sierra Leone. 25% of Latino families and 21% of Black families live below the poverty line, compared to only 8% of white families. And the unemployment rate in the state is close to 8% for Latinos and 9.5% for African Americans, compared to 5% for whites. Those Americans who are stuck at the bottom economically are victimized at every turn. There is little doubt that fraud committed by banks and financial institutions played a key role in the subprime mortgage crisis and the financial meltdown that we witnessed and are continuing to experience the effects of today. And since that time, banks have been foreclosing homes at every turn, and as we know, African American and Latino households, many of these households comprise the first-time homeowners, bore the brunt of this injustice. Significantly, as a result of the foreclosure crisis, the median Black household lost 84% of its household wealth in the bust. 84% of Black wealth lost in the bust. And Latinos lost 66%, almost 2/3 of all Latino wealth wiped out in the foreclosure crisis. All of this compared to the comparable loss for white households, which stood at about 34%. African Americans and Latinos have lost their homes to foreclosure at rates that are more than double the rate of whites. And we know that the struggle we face today is not one just based on class, and that it's not just about money. In fact, nowhere are the disparities more significant and severe than in the context of our criminal justice system, where, for example, Black New Yorkers are 4.5 times more likely than white New Yorkers to face arrest for marijuana possession. We're faced today with a criminal justice system that assumes that Black and brown men are a threat and gives a pass to those who wrongly act on those fears, even when using deadly force. And Trayvon Martin stands as a powerful symbol of that. Stand your ground laws like the one in Florida warrant closer examination and scrutiny. Studies reveal that judges and juries are 10 times more likely to find justifiable homicide when the shooter is white and the victim is Black than when the shooter is Black and the victim is white. In the 5 years before Florida passed the nation's first stand your ground law in 2005, prosecutors there declared an average of 12 killings by private citizens each year to be justifiable. In the next 5 years, that number tripled. Those laws make it open season on innocent, law-abiding citizens every time someone with a gun thinks that somebody might pose a threat, and that's something that's wrong and deeply problematic. What's more, we risk perpetuating the disparities among a new generation of New Yorkers, since 85% of those now incarcerated in our juvenile detention system are minorities. And among students scheduled to graduate from New York City high schools in 2010, only 9% of males, Black males, were deemed college ready, and only 11% of Latino males were deemed college ready. And all of these injustices are creating a permanent underclass in the United States. Education, which used to be a way for disadvantaged people to scale the ladder from economic distress to self-sufficiency, just doesn't do the trick anymore. Let's talk about where we stand with respect to education for a moment. This May marks the 60th anniversary of the Supreme Court's landmark ruling in Brown versus Board of Education. And the holding in the court from that case, as you all know, is that separate is unequal, that schools must desegregate with all deliberate speed. In the late 1960s, shortly after the court issued the ruling, 76.6% of black students went to majority black schools. 76.6%. In 2010, 74% still go to schools that are majority non-white. The reality is that we're still wrestling with deeply segregated schools, and the goals of Brown remain unfulfilled. Schools that are segregated have fewer resources, offer less opportunity for education, and are schools where we see higher dropout rates. So it's not surprising that 50% of young black men today in inner city schools drop out of high school. The problems are especially stark when we look at what's happening with respect to our political process and the State of Voting Rights Act in America today. The Voting Rights Act of 1965, one of our nation's most successful and effective civil rights laws, has literally blocked hundreds of discriminatory voting changes over the course of the past few decades. Discriminatory voting laws that would have otherwise locked out hundreds of thousands of African American, Latino, and other minority voters. However, a recent ruling from the Supreme Court last year in a case called Shelby County, Alabama versus Holder gut the act and rendered one of its core provisions dead. And before the ink was even dry on the court's ruling, states around the country have moved to adopt a series of restrictive voting laws. Indeed, just hours after the court issued a ruling in the Shelby County case, the Texas State Attorney General announced that very afternoon that he was moving forward with a stringent, mandatory, government-issued photo ID requirement for voters in his state. So let's illustrate the impact of this law. In Texas, a concealed gun permit qualifies as voter ID, but a student ID does not. Following in Texas's footsteps, Mississippi, Alabama, South Carolina, and Virginia have also moved to implement restrictive, unnecessary photo ID laws that have now been passed but would not have passed muster under this core provision of the Voting Rights Act. Just before the court issued its ruling in the Shelby County case, Arizona passed a bill that would remove thousands of people from the early voting rolls and criminalize efforts by volunteer groups to provide help in submitting early voting ballots for elderly or homebound voters, or for those who lacked transportation. On July 25th, North Carolina passed what I think is a remarkable set of sweeping laws that have really turned the clock back. The law there not only requires ID, photo ID at polling places, but reduces the early voting period from 17 days to 10, prohibits counties from extending polling hours by 1 hour, even in extraordinary circumstances, such as where you've got long lines, eliminates pre-registration for 16 and 17-year-olds, eliminates provisional voting if somebody shows up at the wrong precinct but is still eligible according to the voter registration list for the voting jurisdiction, and so forth. It's clear that we are turning the clock back. In some total, over the course of 2013, we saw at least 92 restrictive bills introduced in 33 states. If these were not restrictive photo ID requirements for voters, these were laws requiring proof of citizenship, such as a birth certificate, at the time that you go to register to vote? And by a show of hands, how many of you know where or have access to your birth certificate today if you needed it? I'm not raising my hand. I have no idea where my birth certificate is, and I imagine it'd be a real pain and burden to track it down. But many states, that's what you got to do if you want to register to vote. States are passing laws to make voter registration harder, passing laws seeking to end Election Day and same-day voter registration, passing laws to reduce early voting opportunities, passing laws to make it harder for persons with criminal convictions to restore their right to vote, and laws making it harder for students to register and vote in the jurisdiction where their schools are located. In many respects, it's clear that we're continuing to witness a backlash response to the outcome of the 2008 election, the outcome of the 2012 presidential election, and it's important that we remain vigilant now more than ever, and that we renew our efforts to ensure that discriminatory voting efforts do not rear their ugly head in our state, while also considering new strategies for increasing and elevating voter participation here in New York. Just as was the case 50 years ago, an anti-racist, anti-sexist, anti-homophobic, multiracial, multinational, and non-elitist approach and vision to civil rights enforcement and reform is necessary to tackle the grave injustices and inequality that we face today. We need a transformative vision of civil rights, one that seizes on the interconnections between the struggles faced by marginalized groups, and one that recognizes that we share fate, that we have a shared fate. As the chief law enforcement agency for the state of New York, our office is proud to be on the front lines in the effort to fight for justice and equality alongside all of you, alongside all of the scholars and students who are focused on the struggles faced by African Americans, Latinos, LGBT, women, and other marginalized groups, alongside the lawyers, the advocates, and the community organizers. And I want to take a brief moment to talk about some of the work that we have been doing to fight for equal justice here in New York. In every major civil rights case that has come before the Supreme Court, and sadly there has been no short list of them, in every major case that's gone before the Supreme Court, we've led the charge among states filing amicus briefs in these very high stakes matters. We stood up in defense of the Voting Rights Act of 1965 in the Shelby County case that I mentioned earlier. We stood up in defense of the continuing value of racial diversity in classrooms and at colleges and universities, and in defense of the continuing need for race-conscious admissions policies in the Fisher versus University of Texas case. We stood up in defense of marriage equality for all and successfully urged the court to strike down the Federal Defense of Marriage Act, DOMA, in the case of the U.S. versus Windsor. We argued that DOMA violates same-sex couples' rights to equal protection under the law as required by our Constitution, and that DOMA represents an unprecedented intrusion on the authority of states to regulate marriage and promote equality for their citizens. While we received an unfortunate ruling from the Supreme Court in the Shelby County case, we're looking forward and we're urging Congress to respond and act swiftly to restore the strong medicine that has long been provided by the Act, because we know that we need the protections of the Voting Rights Act now more than ever. And outside of the court, we're also on the front lines working to combat discrimination wherever it rears its ugly head. To close some of the wealth gaps that I spoke of earlier, we're working to combat discrimination in the job market and working to ensure full access to equal employment opportunities for all. We recently secured a settlement against a Fortune 500 company for automatically disqualifying job candidates with criminal convictions, no matter what kind of conviction, no matter how old the conviction. We believe firmly in addressing barriers to reentry, and ensuring that once someone has paid their debt to society, they deserve a second chance and should get that second chance. We've also led a statewide initiative to ensure that language barriers do not stand in the way of those seeking to exercise important constitutionally protected rights or seeking to access necessary public services. For example, language barriers faced by those who are limited English proficient are especially substantial in the voting context. As many of you all will recall, how many of you voted in this past election cycle? Good. As you know, there were a number of contests on the ballot and a number of very complex ballot initiatives, about 5 of them. And these ballot initiatives can be even hard to digest if you speak English really well. So you can imagine the barriers faced by those who are limited English proficient. To ensure access to the ballot box, we secured agreements with numerous boards of elections across our state to ensure that all eligible voters are able to meaningfully participate in the process, requiring the translation of everything from the voter registration form all the way through to ballot on election day, and also requiring that boards hire bilingual poll workers. We're also working to address the language barriers faced by students and parents in the education context. And we're also working to address barriers faced by domestic violence victims and crime victims who may not speak English but require access to the protection of police departments. We embarked on this work after receiving many reports from advocates about Spanish-speaking domestic violence victims who would call 911 for help, only to be met by police officers who couldn't speak with them, who would rely on the alleged batterer to translate what happened. And sometimes the victims would find themselves entangled in deportation proceedings. So something that started as a cry for help would morph into something else. And there were victims who were actually deported as a result. So we have secured agreements with a number of police departments, working with them to ensure that they communicate with everybody that they are tasked with protecting and service, regardless of the language barriers that may exist. We also recognize that there's a very important conversation happening right now about policing and about effective strategies for combating crime. And clearly with Mayor de Blasio recently following through on a central campaign promise to withdraw the appeal on the stop and frisk litigation, we're now moving into a new era here in New York City with respect to policing. However, the question remains, what's the right way to police? And what's the right way to ensure that you can combat crime without intruding on the rights of individuals? And what about the cities around our state and around the country that have themselves modeled their policing programs after our NYPD stop and frisk program? Last year, our office endeavored to answer a question that up through this point had long gone unaddressed. How effective is stop and frisk really in combating serious crime? We conducted a study that revealed that the majority of arrests that result from stop and frisk, and about 6% of stops result in arrests. So we looked at those 6% of stops that resulted in arrests to see what happened. And what we found was quite striking. Our study showed that the vast majority of those arrests are dismissed by prosecutors. Those cases never see the courthouse steps. And that only 0.1% of stops led to convictions for violent crime, and only 0.1% led to convictions for crimes involving drugs or dangerous weapons. I think the prevailing view among proponents of stop and frisk up through this point is that this is about life and death This is about ensuring public safety, but when we conducted an empirical examination of the data, that just didn't bear out. And so our hope is that as we move into a new chapter here in New York City, that this study will help crystallize discussion about effective law enforcement strategies that will implicate us here in New York City, but could implicate the policing approaches of departments elsewhere around the state and around the country. We're also fighting to protect the rights of our diverse immigrant communities and working to tackle the fraudulent schemes and services that are too often targeted at these groups. We've have been and continue to go after illegal immigration services providers. These are people who hang up a shingle and basically promise a pathway to citizenship for vulnerable immigrant groups and essentially take the money and run. A really prevalent practice, and whether those entities target immigrants from the Caribbean, Central or South America, Africa, or Asia, we go after those individuals and companies that prey and steal from people. We shut their businesses down, and we seek restitution for impacted individuals. With respect to housing discrimination, we're one of the only state attorney general's offices with a fair housing testing program that enables us to deploy undercover investigators who go out and identify and root out discrimination in the housing market. The discrimination that we continue to face in the housing world has been hard to penetrate and hard to uncover. And what our testers do is they essentially go out, mic'd up, wired up, and we're able to document the comparative differences in the treatment phase, for example, by a Black prospective renter and a white prospective renter. And through our undercover testing, we are able to resolve cases that reveal discrepancies in how African American testers and white testers were treated when asking about available apartments. In one recent case that we resolved, we had a tester who, when they disclosed that they had children, was told no apartments available, and a tester who said that they were without kids, who was walked up and shown several apartments by the very same landlord. So the testing program has proved very effective in combating some of the discrimination that is otherwise hard to identify and uproot. We also believe firmly that there should be one set of rules for all. We're looking at reports of racial profiling of customers, Black customers at Macy's and Barney's. And earlier this year, we went after a popular Midtown nightclub located not too far from here on 41st and Broadway that had in place a discriminatory door policy that locked patrons out solely on the basis of race. So decades after we confronted segregated lunch counters, we know that today we're still battling to ensure that the doors of our public establishments are equally open to all. Our work overall is driven by a recognition that we remain far from post-racial. We believe that our work must be shaped by and responsive to the realities of ongoing discrimination, poverty, unemployment, homelessness, and mass incarceration that too many communities continue to wrestle with. But we're inspired by the possibility that through aggressive and tireless civil rights enforcement and collective action that we might close some of the gaps that persist today. Congressman John Lewis, who has served in distinction in our Congress for the last 27 years and who was brutally assaulted on the Edmund Pettus Bridge in Selma, Alabama in 1965 while peacefully marching to fight for the right to vote, asked, if not us, then who? If not now, then when? So let us collectively use this Black History Month to redouble our efforts, to pledge our commitment to finishing the work that remains undone, to combat the discrimination that persists and stands as a real threat to the very fragile gains that have been made over the course of the past few decades, to producing new scholarship that sheds light on the vast problems that remain and that are not talked about enough, to forge new collaborations and partnerships that can inject fuel and energy into our ongoing civil rights movement, to never abandon the fight for equality, and to keep a laser-sharp focus on the goal of making our democracy more whole. Thank you.